Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about unfair strategic advantage. Cases that should have gone to the Supreme Court of Canada, but didn't. In the course of a criminal trial for fraud, Mr. Accurso had a trial before a jury. Ultimately, due to a number of circumstances, the original jury that was impaneled was dismissed, and a new jury had to be impaneled, a mistrial was declared, and the trial started again. Mr. Accurso argued after his conviction that what had happened amounted to an abuse of process because the Crown was able to gain a strategic advantage and make certain strategic decisions as a result of information that it learned after the first jury was dismissed as a result of the first jury's dismissal. And this gave the appearance or the potential that the trial was unfair. This case would have been a perfect opportunity for the Supreme Court of Canada to really clarify the rules around how new trials take place where there's been a mistrial. If there's been a mistrial, especially if it comes late in the proceedings, that mistrial can potentially taint the future proceedings by creating a situation where strategic decisions, arguments, evidence that was maybe kept quiet by the defense has been led and puts the Crown in a position of being in a strategic advantage for a subsequent trial. In some circumstances, this may incentivize people to cause a mistrial in order to gain an advantage in a second trial. And if there has been a mistrial, shouldn't there be some limitations on the use of evidence that's come as a result of that mistrial that may inform a state actor about how to approach the case better, whether it's strategic decisions about what evidence to lead or how to lead that evidence or how witnesses are going to be received or what witnesses should be called. The Crown shouldn't get the benefit of an unfair trial to get a second chance at a better conviction. And yet that's unfortunately what happens in the circumstances of some mistrials, whether it's intentionally or whether it's unintentionally. The Supreme Court of Canada could have provided some better guidance for trial judges conducting second trials after mistrials to give an indication about how these should be conducted in a way that ultimately leads to a fairer perception of the administration of justice. And unfortunately, the Supreme Court of Canada missed the opportunity to correct what is an apparently concerning situation on the face of the allegations that were made in this case, whether or not they are true. Those allegations deserve commentary by the Supreme Court of Canada so that cases don't have to deal with allegations that strike at the core of the integrity of the justice system like these in the future. Hopefully the Supreme Court of Canada will take another opportunity to address some rules around how a trial after a mistrial should be conducted in order to make sure that there is always an appearance of fairness in our trial process. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.